Hello everyone, this is your host Amir Said and you're listening to VIVAVISA Podcast by Adhami Law Group. In this episode, we answer the questions regarding the SIJS applicant's competency and the proposed guardian's or parent's legal and financial status. But before we begin this episode and talk to attorney Kousha Adhami, I encourage you to check out the show notes for access to our website to ask your questions and learn more about obtaining a green card through the SIJS and asylum programs. Now let's begin. Hey Kousha, welcome to the show.
Good morning, Amir. Thank you for having me.
Kousha, there are lots of questions that we got from our listeners and we're going to talk about them in this episode.
I'm ready.
So, mostly the questions are about the proposed guardian's or parent's legal status, the applicant's competency or eligibility, and the predicate court process. So let's begin. The first question is that do the parents or guardians of minors have to have legal status?
So I just want to kind of rephrase your question. I believe you're referring to the first stage. The answer is no. Since this petition is taking place in state courts do not require any legal status from the proposed guardian or the parent. And that means they do not have to be a legal resident or a U.S. citizen to petition their child or the ward in a guardianship court.
Perfect. The other question that we have, does a guardian have to have a job?
Okay, so I get this question a lot, especially at the beginning or in the middle of the petition that is filed. So when we're referring to guardian, this is the petition that is taking place in the probate court, and it's the petition for guardianship. No. So the standard that the probate court applies in a guardianship court is a necessary and convenient standard. This means that the guardian have to be suitable in order to be appointed as the guardian of the minor or the ward. Ward is another word for the minor or the child in this case. So no, they don't, but they do have to have the financial means to provide for the minor. That means, for example, if a grandmother is petitioning the probate court or guardianship court for SIJS and guardianship petition, if the grandmother does not have a job, but if grandmother lives with grandpa and grandpa is providing for everything, then that should be good enough.
Okay. So what's the difference here between the joint sponsor and the guardian that have no job? How is it possible?
Okay. That's okay. So if I can explain it, because I get that question a lot too. So a joint sponsor is for a petition that is taking place in an immigration setting. That means the joint sponsor is someone who is entering into a contract with the U.S. government on behalf of the immigrating individual, that person will not receive any public assistance from the U.S. government. That usually takes place in family petitions, like for example, if someone is petitioning their parents, children, spouse, or whatsoever. In this setting, we're in actually a guardianship court or probate court, and you're not required to enter into a contract. You just have to show that you have the financial means to provide for the child.
Interesting. So the other question that we have is that can they get married while waiting for a green card? When can they get married? And when we say they, we're talking about the SIJS applicants.
Okay,
yeah.
all right. So let me. Okay, so this becomes a little more complex. I would like to. I know our listeners have submitted this question. So the question of marriage becomes a little complicated because when the whole purpose of SIJS, and in order for a SIJS applicant to be eligible to apply for SIJS with immigration, they have to be unmarried. Okay, so unmarried / never married. So if any time at any stage before the green card is issued, the child, who at this stage could be even like 21 years old, gets married and divorced, that may revoke the petition because it's an unmarried standard. Okay? So, SIJS petitions or SIJS applicants can get married after the green card is issued, and then they can petition their spouse as a U.S. citizen or a green card holder. But the marriage cannot occur before the green card is issued. That's very important. I tell this to my clients that you must remain unmarried until you at least get your green card.
So, it's a little bit complicated.
It's very complicated.
Because there are lots of people, maybe they are married or,
I think they want to get married or they, want to help their significant other.
Right.
But that's going to disqualify them because the definition of a minor or a child for the purpose of SIJS is an unmarried person under the age of 21. So I guess the complexity of this question will be when can they get married?
Right.
They cannot get married until the green card is approved.
Oh.
Yes. So that means
the whole process
at the state court stage,
right.
First stage, they cannot get married. When they file the I-360, they cannot get married. When the I-360 is approved, they cannot get married. When they're filing the green card, the I-485, they cannot get married. Once the I-485 is approved, they can get married.
When the
I-485 or the green card is approved,
right.
They can get married.
So I don't remember if you talk about it, but if a person, the applicant is under 21 and he or she divorced before applying for the SIJS, then what will happen to them?
Okay. You need to define the period of them getting married and divorced. When did the marriage take place?
For example, he was 18 years old, 19 years old.
No, I understand. What was it before the petition?
Yes.
Okay.
Before petition.
So if they got married
right.
at the age of 18, that's going to come up with this scenario. And then they got divorced. Then the petition for guardianship was filed. And then they filed the I-360. That's a good question.
It could happen. It's a case. Maybe it happened.
I guess USCIS will look at the definition of unmarried, and is unmarried defined as someone who has never been married or someone who could have been married but they were divorced.
But the moment that they're applying, they're not married.
They should not be married.
Of course.
Yeah.
Of course. But if they divorce before petitioning, that's a question that we don't know. Maybe the court.
I would have to do some research on that one.
Right. It's going to be really good if you can understand. Because the people that sometimes, it's not legal, I know that, they divorce because of the SIJS,
right.
Then they apply, and then when they apply, they got they got the green card.
Right.
Then they can get back to the loved one and then to do the marriage. Right.
It is a possibility.
It is a possibility.
Right.
Maybe it's illegal. I don't know, but it could happen. It's a case. It could happen.
Yes, it could.
Right.
And as a green card holder, you can petition your spouse.
Right.
Yeah.
Right. Mm-hmm. The only thing that we cannot petition for is the parents. We cannot petition for the parents.
They can never petition their parents.
Right.
Yeah.
Right.
Both parents.
Gotcha. Okay. The other question that we have is that does a minor or SIJS applicant have to attend school for the court to approve the petition?
Okay. I'm actually going through a case with this. So when this is actually more I guess this is more addressed at the guardianship court. So the child or the minor is not required to attend school in order to be appointed a guardian. However, the probate judge or the guardianship judge will want to know why the child is not going to school. In fact, I have one client right now who is not going to, who doesn't have a good attendance in school, and the judge has appointed a guardian ad litem, a minor's counsel, to make sure that he goes to school.
Why does it matter?
Why does it not matter? Why do you want a child who's 17 years old not to go to school?
That's their choice.
No.
What do you mean by no?
If the parents want them to go to school, and they're gonna end up in the streets. They should be going to school.
So it's
what are you gonna do if you're 17 years old?
Right.
You're not working full time. You're not providing. Okay. What should you be doing? You should be going to school.
Right. But if someone wants to work, he or she is 17 years old.
They can get a permit from school. Okay.
Okay,
and
gotcha.
They have to have valid authorization to
Gotcha.
work. They can go part-time to school and full-time to school and part-time to work. Yeah, that's fine. But they should not be going to school.
So it's a must that if the applicant...
It's not a must in a sense that they have to go to school.
Mm-hmm.
It's a must when the parent
Right.
wants them to go to school. And how would I word this? Okay, so if you have a parent who is homeschooling their child, then that's fine. They don't have to go to public school or anything, but they still need to receive their education. And where judges are more reluctant to not grant petitions if the child is not cooperating. They want to make sure that there's cooperation between the child and the parent.
So, it's like a positive point.
Absolutely.
If you want to go to
It's
school,
a positive factor.
right?
Yes.
Right.
Yes. It's not a requirement, but it's a positive factor.
It helps a lot.
Yes.
To go to school, to show that you are qualified to have that opportunity.
That is correct.
Right.
Yes.
And then there's when the judge sees that you are going to do that, they can help you.
In this case, the judge actually asked to see the minor's report card. We had to produce the report card.
Report card of the school?
No, the minor, yeah,
Right.
Minor's report card from school, and with this particular situation, it's very rare. My client, he's a very good kid. He's fantastic. He's has problem like adjusting, and so the judge made him have teachers sign to show
Right.
that he is attending school.
Yeah. Oh,
Yeah.
got you.
Yeah. So the judge has a lot of discretion.
Judge is looking to figure out if this petition is the one that can help the society of the United States.
No.
That's why they're looking for. They have to go to school. They have to have proper
It's about
job.
the child's best interest. The judge will want to make sure that, the petition that is put in front of him or her is a petition that will be in the best interest of the child. It's called the best interest factors. So when the judge sees a petition and a mom who's frustrated with the child and who's not going to school, despite everything she's doing, she's working full time, she's a single parent mom, and the child is not going to school, obviously that's something that the judge doesn't want to see. So it's we're not saying that if you go to school, then you're set for the rest of your life.
Right.
We know for sure that's not the case. However, we know that school provides a much more positive and reinforcing environment for a child at that age to flourish. I guess we can just leave it as going to school is a big positive factor in the petition.
Right. And even they check your background to make sure there's no criminals or anything like that. Because you said that they have to provide the evidence for the court that this petition is qualified to get that opportunity.
I believe you're referring to the probate investigation.
Right.
That's when the probate court investigates the proposed guardian. They want to investigate and they do a background check on the guardian. Who are you referring to? Are you referring to the child or are you referring to the...
I'm talking about the child.
Okay.
If a child was involved with any criminal things.
Give me an example.
For example, a child was arrested because of, drug, of driving
possession of I believe maybe marijuana or something.
Marijuana, carrying a ghost gun, or different things like that.
Okay.
These are the things that are, are considered as a criminals, right?
Okay.
It's not legal.
Okay.
Then what will happen to those to those kids?
Okay. All right. So it depends at what stage we're in. Okay. If we are at the second stage, which is the I-360 stage, I believe so arrests and convictions will not come up until the child gets fingerprinted. So it would be until the third stage where USCIS will want to clarify this position. Now, if we are at the first stage and we are dealing with the guardianship court, and a probate investigation has been conducted, and the probate investigator has found that the child is having problem and having criminal matters, then they would make this recommendation to the judge. And depending on the situation, and depending on how the guardian or the parent is behaving, if the parent is cooperative, meaning that the parent is doing everything in his or her hand to prevent this from happening, that they're gonna put some orders in place to make sure that the minor is in compliance.
Perfect. Okay, Kousha, thanks for joining us, and I want to say thank you to our listeners. I hope you enjoyed and learned from today's episode. Make sure to check out the show notes with the description for access to our website. Also, make sure to share this episode with your friends and subscribe wherever you listen to your podcast. We really appreciate hearing feedback from you, so please share a review for this episode or check out our website and ask your questions. We are located in 21031 Ventura Boulevard, suite number 760, Woodland Hills, California 91364. You can also call us at 213-204-6500. Until the next episode, take care and bye.